Talk shoes. Recorded live.
All right, welcome everybody. It is Wednesday night, 8 p.m. Eastern Time, and we are going to go ahead and jump right into it tonight. But before we do, we're going to read our notice and acknowledgement agreement. This show and our documents is private, not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice or guidance by a licensed attorney. This private show and our documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show and documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance or advising or guidance of any kind, used by non-attorneys or opposing parties in the preparation or use of the reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as may on the communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. The documents and short recordings are incomplete and void without this notice agreement being attached herein by reference, and are breach of this agreement. On breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more for stultification or impairment per Christian Walters' discretion. All right, Chris, did we find out where we were tonight?
Well, I kind of, maybe. I think last week we started out on Section 3, who may be the City Key Trust, yep. And we went through some sections, and we went through the statutes of frauds, and I forget, did we get into the statutes of wills? Not.
I don't remember.
I think we may have stopped at the step where the writing must be signed. Does anybody recollect or not?
Anybody out there remember?
You are unmuted.
Do we have anybody here from last week that remembers?
I think it was right before Section 3, the statutes of wills, maybe.
Okay.
Anyway, I think we'll start there. I think that's where we left off. Okay, I believe it's page 76. It's the very ending, number 4, under the section Statutes of Frauds, the formalities. Page 76. Number 4, the writing must be signed. I believe that's where we should pick up at. Okay, number 4, the writing must be signed. Page 76. It would be observed that the word of the statute required the writing to be signed, and not only the fact of the trust, but also the terms of it must be supported by evidence under signature. But as an analogous case of agreements under the 4th section of the Act, the terms of the trust may be collected from a paper not signed, provided such paper can be clearly connected with and is referred by the writing that is signed. Number 5, who is the party enabled to declare the trust? The signature must be by the party who is by law enabled to declare such trust. It has been occasionally contended that by this description was meant the person seized or possessed of the legal estate but it has been decided that whether the property be real or personal, the party enabled to declare the trust is owner of the beneficial interest and who has therefore the absolute control over the property, the holder of the legal estate being a mere instrument or conduit pipe, where therefore in a nuptial agreement that the intended wife's realty could belong to her for her separate use was signed only by the husband, the fee was not affected by the agreement so as to enable the wife to devise it as separate property. It was held in a recent case by Cave J that a parole agreement entered into in contemplation of a marriage, that property consisting of a sum of money standing to the credit of the wife in her maiden name at her bankers should belong to her for her separate use, but not followed by any transfer to trustees, did not constitute a good nuptial settlement, but the Court of Appeal, while reversing the decision upon other grounds, withheld their opinion upon the point. Next, Section 3 of the Statutes of Wills. Number 1, the Statutes of Frauds. By the 5th section of the Statute of Frauds, all divisees of lands are required to be in writing and signed by the testator, or by some person in his presence and by his discretion to be attested or subscribed in his presence by 3 witnesses. And by the 19th section, all bequeaths of personal estate are required to be in writing, with the exception of certain specified cases in which nuncupative wills were allowed. And by the 1st Victoria, Section 26, subsection 9, wills made on after January 1st, 1838, whether of real or personal estate, must be executed and attested with special solemnities there mentioned. Number 2, principle of rejecting declarations not testamentary in respect to wills. To trace the operation of these enactments, we must bear in mind the absolute owner of the property combines in herself or himself both the legal and equitable interest. And when the legislature enacts no divisee or bequeath of property shall be valid without certain ceremonies, a testator cannot by informal instrument affect the equitable any more than the legal estate, for the one is a constituent part of the ownership as much as the other. Thus, if a testator by will duly signed and attested giving lands to A and his heirs upon trust, but without specifying the particular trust intended, and then by a paper not duly signed and attested as a will or a codicil, declare a trust in favor of B, the beneficial interest under the will is part of the original ownership and cannot be passed by the informal paper, but will descend to the heir at law. And if the will be made since 1837 and contain a residuary divisee, will pass to the residuary divisee. So if a legacy be bequeathed by a will duly executed to A upon trust, and the testator by parole evidence or parole express an intention that it shall be held by A upon trust for B, such a direction is in fact a testamentary disposition of the equitable interest in the chattel, and therefore void by the statute, which requires a will duly executed. If it be said that such expression of intention, though void as a divisee or bequeathed, may yet be good as a declaration of trust, and therefore that the will and legal estate of the freehold is well devised, a trust may be engrafted upon it by a simple note in writing. And where a chattel personal is well bequeathed, a trust of it, as accepted from the 7th section of the Statute of Frauds, may be raised by a mere parole declaration. The answer is that a wide distinction exists between testamentary dispositions and declarations of trust. The former are ambulatory until the death of the testator, but the latter take effect, if at all, at the time of the execution. A deed, observed Mr. Justice Buller, in a similar case, quote, must take upon its execution or not at all. It is not necessary for a deed to convey an immediate interest in possession, but it must take a place as passing the interest to be conveyed at the execution. But a will is quite the reverse, and can only operate after death, unquote. It seems, therefore, on principle, that if the intended disposition of the testamentary character and not to take effect in a testator's lifetime, but to be ambulatory until his death, Such disposition is inoperative unless it be declared in writing in conformity with the statutory enactments regulating divisees and bequeaths. Page 80, Section 3, where no trust appears on a will and no fraud. If a testator by his will devised an estate and the divisee, so far as appears on the face of the will, is intended to take the beneficial interest, and the testator leaves a declaration of trust not duly attested and not communicated to the divisee and assented to by him in the testator's lifetime, the divisee is the party entitled both to the legal and beneficial interest, for the estate as well devised by the will, and the informal declaration of trust is not admissible in evidence. This doctrine, of course, does not interfere with the well-known rule that a testator may, by his will, refer to and incorporate within any document which at the date of the will has an actual existence and is thus made part of the will. Number 4, where the divisee is made by the will of a trustee and the testator leaves an informal declaration of trust. Should the testator devise the estate in such language that the will passes the legal estate only to the divisee and manifests an intention of not conferring the equitable, in short, stamps the divisee with the character of trustee, and yet does not define a particular trust upon which he is to hold, in this case, no paper not duly attested, except, of course, papers existing at the date of the will and incorporated by reference, will be admissible to prove what were the trust intended. Nor will the divisee be allowed to retain the beneficial interest himself, but while the legal estate passes to him, the equitable will, according to the date and terms of the will, result to the testator's heir at law or general residuary divisee. Number 5, personal estate. So if by will personal estate be given upon trust to be afterwards declared, the testator cannot by any instrument not duly executed as a will, and a fortiori can not by parole declare a valid trust, but the equitable interest will result to the next of kin or pass the residuary legatee, and the same rule will be applied if the bequeathed be on the face of the will one beneficial one, but the legatee undertakes to hold upon trust to be afterwards declared. 6. But where the personal estate was by codicil given to the legatee, quote, to be applied as I have requested him to do, unquote, and an unsigned memorandum was written out by the legatee at the time of the executing the codicil containing the wishes of the testator, it was held by V.C. Hall that the court would execute the trust. 7. Admission and rejection of parole evidence as against the title of executors. So if a person before the Act of 11G4 and 1W4, Section 40, had been simply appointed executor, which conferred upon him a title to the surplus beneficially, affirmation was not admissible to make him a trustee for the next of kin. But apparently the authorities established that if any in circumstance appearing on the face of the will as the gift of a legacy to the executor, the law presumed only that he was not intended to take the surplus beneficially. The executor might rebut that presumption by the production of parole evidence, when, of course, the next of kin might fortify the presumption by opposing parole evidence in contradiction. Where, however, the will itself invested the executor to the character of the trustee as by giving him a legacy for his trouble, or by styling him a trustee expressly, the prima facie title to the surplus was then in the next of kin, and parole evidence was not admissible to prove the expressed intention. By the act referred to, an executor is made prima facie a trustee for the next of kin, but where there are no next of kin, the title of executor as against the crown is not affected by the statute, and the old law applies. But if the executor be stamped by the will with the character of trustee, and there are no next of kin, the crown will take. And of course, whether it be next of kin or not, if it appear from the whole will that the executors were intended to take beneficially, the statute is excluded. 8. Fraud. An exception to the rule that parole trust cannot be declared upon an estate devised by a will exists in the case of fraud. The court will never allow a man to take advantage of his own wrong, and therefore, if an heir or divisee or legatee or next of kin contrive to secure himself a succession of the property through fraud, the court affects the conscience of the legal holder and converts him into a trustee and compels him to execute the disappointed intention. Case of fraud and error. Thus, if the owner of the estate hold a conversation with the heir and be led by him to believe that if the estate be suffered to descend, the heir will make the certain provision for the mother, the wife, or the child of the testator. A court of equity, notwithstanding the statute of wills, will oblige the heir to make a provision in conformity with the express or implied engagement, for the heir ought to have informed the testator that he, the heir, would not hold himself bound to give effect to the intention, and then the testator would have had the opportunity of intercepting the right of the heir by making a will in divisee. Next section. So if the father devised to his youngest son, who promises that if the estate be given to him, will pay £10,000 to the oldest son, the court, at the instance of the eldest son, will compel the youngest son to disclose what passage between him and the testator, and if he acknowledged the engagement, though he pray the benefit of the statute of bar, he will be a trustee for the eldest son to the extent of the £10,000. In legatee, next section. And so generally, if a testator devised a real estate, bequeathed personal estate to A, the beneficial owner upon the face of the will, but upon the understanding between the testator and A, that the divisee or legatee will, as to part of or even the entirety of the beneficial interest, hold upon any trust which is lawful in itself in favor of B, the court, at the instance of B, will affect the conscience of A and decree him to execute the testator's intention. But in this, as in other cases, if it appear that A was not meant to be a trustee but to have a mere discretion, the court cannot convert the arbitrary power into a trust. Next section 9, intention not communicated. But were the bequeathed on the face of the will a beneficial one, the understanding between the testator and the legatee was that he should take the property as trustee upon trust to deal with, and according to the further directions which the testator was to give by letter, and the testator subsequently wrote letters containing direction, but never sent them or communicated their contents to the legatee. It was held that the legatee was a trustee for the next of kin, and it was considered to be essential for the validity of the trust that it should be communicated to the legatee in the testator's lifetime, and that he should accept the particular trust. 10. Admission by one joint tenant. Where the property was devised into 4 persons as joint tenants, and one of them in his will made certain statements that he pointed to a secret trust, it was held that the statements could not affect the rights of the survivors of the joint tenants, and in the absence of the other evidence, his representatives were held to be entitled to the property. Number 11, engagement to execute an unlawful trust. It often happens that a proposed divisee enters into an engagement with the testator in his lifetime to execute a secret trust of an unlawful character, one which the policy of the law does not allow to be created by will, and in this case the court will not suffer the divisee to profit from by his fraud, but on proof of the fact raises a resulting trust in favor of the testator's heir at law. If, therefore, the testator devised an estate in words carrying upon the face of the will the beneficial interest, and obtain a promise from the divisee, whether expressed or tacitly implied, that he will hold the estate upon trust for a charitable purpose, the heir at law is entitled to a resulting trust, may bring an action against the divisee, and compel him to answer whether there existed at any such undertaking between him and the testator, and if the defendant acknowledged it, it will be decreed a trustee for the plaintiff and convey the estate to him accordingly. Number 12, devised may be good as to one and void as to another. Where a divisee is several persons as tenants in common, it may be void as to one to whom the testator's unlawful intention was communicated in his lifetime, and good as to others who were not privities to his intention. But if it be a joint divisee to 2, one of whom has active fraud procured the devise, and other cannot claim under the fraud, but the devise will be voided as to both. 13. Devise not void because divisee means to execute unlawful trust. Where no trust is imposed by the will, and no communication was made in the testator's lifetime, the devise will be good, although the divisee may, notwithstanding the absence of legal obligation, be disposed from the bent and impulse of his own mind to carry out what he believes to have been the testator's wishes. 14. An engagement to hold an indefinite part of the estate upon an unlawful trust. A divisee may be a beneficial one upon the face of the will, but there may have existed an understanding between the testator and his lifetime that the divisee, that without any particular part of the estate being specified, such portions of it as the divisee, in the exercise of his discretion, might think proper, should be applied to a charitable purpose. Under such circumstances, the heir of the testator would have a right to interrogate the divisee whether he has exercised that discretion and to call for a conveyance of so much as the divisee may have made subject to the unlawful purpose. 15. Defendant must discover what the secret trust was. In the above cases, it is not a sufficient answer as to an action by the heir for the defendant to say that a secret trust is not for the plaintiff, for thus the divisee makes himself the judge of the title. The trust may be for a charity, and if so, the beneficial interest would result from want of a lawful intention, or the equitable interest might, on some other ground, inure to the heir as undisposed of. If the defendant denied the trust by his answer, the fact in this, as in other cases of fraud, may be established against him by parole evidence. Engagement to execute a trust and no trust declared. It is clear that if the divisee enters into an engagement with the testator to execute an unlawful trust, the heir may bring an action and claim the beneficial interest. But suppose the divisee is a beneficial one upon the face of it, and the testator communicates his will to the divisee and requests him to be a trustee for such purposes as the testator shall declare, which the divisee undertakes to do. But the testator afterwards dies without having expressed any trust. It seems that in this case, also the divisee will not be allowed to take the beneficial interest, but the heir at law will be entitled. 17. Cases of divisee made a trustee on face of the will and parole declaration of trust for a stranger. Another case distinct from all the proceedings is where a testator devises an estate to persons as trustees, but no trusts are declared by the will, so that the equitable interest would, upon the face of the instrument, result to the heir at law, and the testator inform the divisees that the intention in making the divisee is that they hold the estate in trust for certain persons, which the divisee undertakes to do. Will the court, under the circumstances, compel the divisees to execute their parole intention, or will the equitable interest result to the heir? In favor of the parole trust, it will be argued that the testator left his will in a form in which it appears under the impression that the object verbally communicated would be carried out, and that the trust can therefore be supported on the ground of mistake in himself or fraud in the divisee is in not appraising the testator that the trust could not be executed. To this, the answer is that upon the face of the will, the equitable interest results to the heir at law, and that if the testator has not disposed of the equitable interest as required by the statute, the court cannot make a will for him. On the plea of mistake or fraud, that the court has interfered with the case of fraud in these instances only where the divisee take the beneficial interest under the will was the contriver of the fraud, and as no man may take advantage of his own wrong, the court compels the divisee to execute the intention fraudulently intercepted. But in the case supposed, the legal estate only is the divisee's, while the beneficial interest is the heir at law, who is wholly disconnected from the fraud. What jurisdiction, therefore, has the court to act upon the conscience of the heir, to deprive him of that estate which has not been devised away according to the statutes of will? And how can the trustee of the heir be held to be trustee for another in the absence of all fraud on the part of the heir? it would seem upon principle that where the trust results from the face of the will, the circumstance of an express or an implied promise on the part of the divisee to execute a certain trust is not a sufficient ground for authorizing the court to execute the trust as against the heir at law. 18. Case of parole declaration of trust as legacy for a stranger. However, in recent case in Ireland where pecuniary legacy was given, quote, to be disposed of by the legatee in a manner of which he alone should be cognizant and as it contained in a memorandum which the testator should leave with him, unquote, the testator before the execution of the will verbally informed the legatee of the manner in which he was to dispose of the legacy, to which the legatee assented. It was held that there was a valid trust and that the legacy was to be applied according to the testator's directions to the exclusion of the claims of the residuary legatees. 19. Effect of the statute of mortmain. We have stated the effect that if a testator make a devise carrying the beneficial interest on the face of the will, but appears from the admission of the divisee or the evidence that the divisee was pledged to the testator to execute a charitable trust, the court will not allow the execution of such trust, but will give the estate to the heir at law. The question here suggests itself whether the statute of mortmain, which declares a divisee, quote, in trust for the benefit of, unquote, a charity to be absolutely void, applies to such a case so as not only to defeat the equitable interest admitted or proved to have been intended for a charity, but also to make void the device of the legal estate itself, so that by the effect of the statute, when the fact has been established, the divisee takes no interest either at law or in equity. After some conflict of authority has now been decided that the divisee of the legal estate is good, but that equity will set it aside on the ground of fraud upon public policy. Now let me find my next section here. Where are we at? All right, page 90. Provisions of the statutes of frauds relating to wills now have been repealed, but the principles established by the foregoing cases with reference to the statutes of frauds will apply, mutandis mutandis, to the enactments of the statutes of wills at present in force. Next chapter, chapter 6, the transmutation of possession, page 91. Where there is a valuable consideration and the trust is intended to be created, formalities are not of minor importance, since if the transaction cannot take effect by way of trust executed, it may be enforced by a court of equity as a contract. But where there is no valuable consideration and the trust is intended, it has been not unfrequently supposed that in order to give the court jurisdiction, there must be transmutation of possession. That is, a legal interest must be devised to the settlor and transferred to some third person. But upon a careful examination of the authorities, the principles would be found to be that whether there was transmutation of possession or not, the trust will be supported, provided it was in the first instance perfectly created. The case upon this subject may be marshaled under the following heads. Number 1, where some further act is intended. It is evident that the trust is not perfectly created where there is a mere intention of creating a trust or a voluntary agreement to do so, and the settlor himself contemplates some further act for the purpose of giving it contemplation. 2, where the settlor declares himself a trustee. If the settlor possesses to convert himself into a trustee, then the trust is perfectly created and will be enforced as soon as the settlor has executed an express declaration of trust, intended to be final and binding upon him. And in this case, it is immaterial whether the nature of the property be legal or equitable, whether it be capable or incapable of transfer. Grantor as trustee within himself, by declaration alone. Continuing on, page 93. 3. Gift of husband to wife. Prior to the Married Women's Property Act of 1882, the husband was incapable of making a gift of chattels at law to his wife, and therefore, if he purported to make such a gift, a court of equity considers it a tantamount to a declaration, and the husband would entrust for the wife for her separate use. The words of gift need not be in writing or of a technical description, but it must be clear, irrevocable, and complete. The unsupported testimony of the wife on her behalf will not be sufficient. But if the gift may be proved not only by witness at the time, but also by the husband's subsequent declaration, quote, if, observes J. Romley, M.R., A, who has 1,000 pounds consols standing in his name, says to B, quote, I give you 1,000 pounds consols standing in my name, unquote, that in my opinion would make A trustee for B. And it would be valid declaration of trust for B, though the stock remain in the name of A. So where a husband by a deed poll, after reciting that he is beneficially possessed of the ground rents, thereby agreed to be settled, quote, settled, assigned, transferred, and set over to his wife as though she were a single woman, unquote, certain leaseholds, houses, and other ground rents thereof, it was held by the deed and was not void as being intended assignment, but operates as a declaration of trust. So where a husband by deed assigned leaseholds to his wife for her executors, administrators, and assigns as her separate estate, it was held that the deed operated as a valid declaration of trust. But these cases have since been disproved by V.C. Hall, who held that the principle laid down by Leroy versus Lord applies equally to the imperfect gift from husband to wife as a gift to a stranger, and that such a gift cannot be supported as a declaration of trust. And this view has since been adopted in Ireland. Next, page 96, number 4. Now, by the recent act, Section 1, a married woman is capable of acquiring and holding property as her separate property, and if she were a femme sole without the intervention of any trustee, and a gift by a husband to his wife will now be valid, as well as at law as in equity. But by Section 10, it was provided that nothing in the act contained shall give validity against creditors if the husband to any gift by the husband to his wife of any property after which after such gift shall continue to be in the order and disposition of reputed ownership of the husband, or to any deposit or any other investment of the monies of the husband made by or in the name of his wife in fraud of his creditors. But any money so deposed or invested may be followed as if the act had not been passed. And since the act has put a gift by the husband to his wife on a similar footing to a gift to a stranger, the principles governing imperfect gifts to strangers must equally apply to gifts from husbands to wife. Number 5, where the property is legal interest. If it be proposed to make a stranger the trustee and the subject of the trust is legal interest and the one capable of legal transmutation as lands or chattels which pass by conveyance, assignment, or delivery, or stock which passes by transfer, in this case, the trust is not perfectly created unless the legal interest be actually vested in the trustee. It is not enough that the settlor executed a deed affecting to pass it, and that he believed nothing to be wanting to give effect to the transaction. The intention of divesting himself of the legal property must in fact be executed, or the court will not recognize the trust. Quote, I take the distinction, unquote, said Lord Eldon, to be that if you want the assistance of the court to constitute a Sedekee trust and the instrument is voluntary, you will not have the assistance of the proposed purpose of constituting a Sedekee trust, as upon a covenant to transfer stock. But if the party has completely transferred stock, though it is voluntarily, yet the legal conveyance being effectively made, the equitable interest will be enforced by this court. If, however, the settlor proposed to transfer the legal estate to a trustee, but the trustee afterwards disclaims, the accident of the disclaimer has been held not to vitiate the deed, but the court will appoint a new trustee. 6. where the property is legal interest incapable of legal transfer. If the subject of the trust be a legal interest but one not capable of legal transfer, then whether we look at the principal or authority, there is considerable difficulty. On the one hand, it may be urged that the universal rule is that the court may not enforce a voluntary agreement in favor of a volunteer, as by the supposition the legal interest remains in the settler, who therefore at law retains the full benefit. A court of equity will not, in the absence of any consideration, deprive him of that interest which he has not actually parted with. On the other hand, as the settler cannot divest himself of the legal interest, to say that he shall not constitute another a trustee without passing the legal interest would be to debar him from creation of a trust in the hands of another at all, and the rule therefore should be that if the settler take all the assignment of the property in his power and perfect the transaction as far as the law permits, the court in such a case should recognize the act and support the validity of the trust. Some judges have adopted the one view of the question and some the other, but the leading case of Keekiewicz versus Manning, Lord Justice K. Bruce observed, "It was upon legal and equitable principle we apprehend clear that a person sui juris affecting freely, fairly, and with sufficient knowledge ought to have and has in his power to make in a binding and effectual manner a voluntary gift of any kind of his property, whether capable or incapable of manual delivery, whether in possession or reversionary or howsoever circumstanced. It has been convinced that the principle will for the future prevail, but since the debts and legal choices and actions have been made transferable at law, questions under this head will be of less frequent occurrence. Where the subject was incapable of transfer as a debt, the parole declaration of a trust was made to the debtor, who undertook to hold upon those trusts. It was held to be a valid settlement without any transfer or attempt at transfer. 7. Where a person wrote a letter to one of the two trustees of the settlement made on her first marriage, stating that he was desirous of making a settlement of 6 policies on the children of that marriage, and undertaking to make to the trustee another trustee to be named by the settler, an assignment by way of settlement of the policies, and until the settlement was executed, he was to be bound by the agreement as if the settlement were actually executed. And afterwards he sent to the trustee another letter enclosing the formal letter of the 3 policies, and the other 3 being in the possession of the mortgagee, and stating that the enclosed was the formal letter of assignment previous to the deed and as binding. But no notice of the letters was ever given to the officers, no formal settlement was ever executed, and no second trustee was named. It was held by V.C. Hall that a complete assignment of the policies had been made and that the settlement of the policy was binding and effectual. It may be doubted whether, as this case was rightly decided, inasmuch the execution by the settler of the further instrument was contemplated and the facts necessary in order to carry out his intention, but no new principle was intended to be introduced, and the Vice Chancellor treated the case as falling within Fortescue versus Bennett and Pearson versus Amicable Insurance Office. If the settler assigned all the personal estate with a power of attorney, the deed being perfect and all was intended, will pass the promissory note without, notwithstanding the want of endorsement, which is required for giving it currency. 8. If the subject of the settlement be partially incapable of legal transfer and partially capable, and that part which is capable of transfer is not transferred, it is in this case all that has not been done might be done, and no trust is created. Thus, where there is a mortgage and fee and the mortgagee assigned a debt with a power of attorney but did not convey the mortgage lands, though they were legally transferable, it was held that the settlement was incomplete. Number 9, 36 and 37 Victoria, Section 66. By a recent act, 36 and 37 Victoria, Section 66, subsection 25, subsequent subsection 6, quote, any absolute assignment by writing under the hand of the assigner, not purporting to be by way of a charge only, of any debt or legal truce in action of which express notice was given shall be given to the debtor, trustee, or other person from whom the assigner would have been entitled to receive or claim such debt or truce in action shall be and be deemed to have been effectual at law, subject to all equities that would have been entitled to priority over the right of the assignee if that act not passed. To pass, the transfer legal right to such debt or truce in action from the date of such notice, unquote. The notice may be given at any time after the death of the assigner, but the effect of delaying to give notice will be to let in any equities arising in the interval before the notice is given. Number 10, where the property is in equitable interest. If the subject of the trust is to be equitable interest, then the authority of Sloan versus Cadogan, a valid trust is created when the settlor has executed an assignment of it to be a new trustee, for an equitable interest is capable of transmission from one to another, and here the court finds the relation of trustee and sedicee trust established without the necessity of calling on the settlor to join in an act for giving it completion. The late Vice Chancellor of England questioned the case of Sloan versus Cadogan upon this point, but in Kikiewicz versus Manning, the Lord Justice K. Bruce observed, suppose stock or money be legally vested in A and the trustee for B for life and subject to B's life interest for C. Absolutely. Surely it must be competent to C in B's lifetime or with or without the consent of A to be the effectual gifts of C's interest to D by way of pure bounty, leaving the legal interest and legal title untouched. If so, C can do this better, more effectually than by executing an assignment to D. The principles have since been acted upon, and Sloan versus Cadogan may be regarded as law. It has been before contended that the assignment operated by way of contract, and there has been no consideration the court would not enforce it, but the rule now is that the assignment passes the equitable estate. 11. Where a new trust is created without new trustees. In other cases, a person entitled to the equitable interest, instead of assigning it to new trustees, has directed the old trustees to stand possessed of it upon the new trust, and of course it has been considered quite immaterial whether the settlor selected new trustees or was content with the original trustees. 12. Assignment to a stranger for his own benefit. In other cases, the owner of the equitable interest has simply assigned it to the stranger of the stranger's own benefit, which also is, in principle, is the same as Sloan versus Cadogan, for there can be no difference between the gift of an equitable interest to A himself and the gift of it to B in trust for A. 13. Case of particular mode intended, but not effectual. If the settler intended to make the settlement in one particular mode, but which fails, the court will not go out of its way to give effect to it by applying another mode. If the settlement be intended to be made by transfer of the legal estate, the court will not hold such intended by effectual transfer to operate as a declaration of trust, for then very imperfect instrument would be made effectual by being converted into a perfect trust. Meek versus Kettlewell. In cases heard before Sir W. Wigram and affirmed by Lord Lyndhurst, it was held that a voluntary assignment of a mere expectancy as of an heir or a next of kin in an equitable interest and not communicated to the trustees did not amount to the creation of a trust. It was the only point decided, and perhaps the distinction may be said to exist between the settlement of an actual interest and an expectancy. For a trust to be enforced must be perfectly created, whereas any dealing with what a person has not, but only expects to have, must necessarily in some sense be inferior. However, Sir J. Wigram in the course of his judgment, denied any distinction existed between settlements of a legal interest, as in Edwards versus Jones, and of an equitable interest, as in Sloan versus Cadogan, two cases which, both on principle and authority, ought not to be confounded. 15. Notice unnecessary. Great importance also attached to his honor to the circumstances that notice of the assignment was not given to the trustees, but notice in these cases was not indispensable. As given the settler, the equitable interest is perfectly transferred without notice. It is only as between purchasers that the service of notice on the trustee, or want of it, has a material effect upon the transfer. Settlements sustained in settler's possession. If a person execute a voluntary settlement in which is duly sealed and delivered at the time, but the settler keeps it in his possession and never parts with it, the settlement is nevertheless as binding as if it had been handed over to the parties entitled. But as a case of conveyance upon a sale, though the deed be duly sealed and delivered, the word escrow be not used, yet if it be retained in the hands of the vendor's solicitor, it has no operation until handed over to the purchaser on payment of the purchase money. The distinction is that in the former case, nothing remains to be done, but in the latter case, the substance of the agreement to the one, viz. The payment to purchase money, is still to be performed. You might want to reread that little section there again. 17. Where donee incurs expense in respect to the property. Although the settlement be voluntary at the time, the legal estate does not pass, yet if the donee with the knowledge and sanction of the donor incur expense in respect of the property upon the faith of the gift, the donee is no longer regarded as a volunteer, but in the character of purchaser, may call for conveyance of the legal estate. Next section, 18. Voluntary settlement by way of trust, not revocable by the settler. If a complete voluntary settlement, whether with or without, whether with or without transmutation of possession, be once executed, it cannot be revoked by subsequent voluntary settlement, and the circumstances of the legal estate which vested in the trustee becomes afterwards by some accident revested in the settler is immaterial, as he will take it as a trustee. But if the voluntary settlement be in trust for the settler for life, and then the trusts for others be subject to such debts as the settler may leave, the settler may in effect nullify the settlement by creating new debts. 19. Fraud. A voluntary settlement, though complete with the face of it, may be set aside in equity, whether obtained by undue influence or whether it was not intended to take effect in the events which actually happened. It was therefore executed under a mistake. 20. But in case of lands be defeated by a sale, a voluntary settlement of land by way of trust perfectly created is liable under 27 Elizabeth, Section 4, like a settlement of the legal estate to be defeated by a subsequent sale to a purchaser, even with notice. And the City Key Trust can neither obtain an injunction against the sale, though the settlement was founded on meritorious consideration as provisions for the wife or child, nor follow the estate into the hands of the purchaser, nor charge him with misapplication of a purchased money if, with notice of the voluntary settlement, he paid it to the vendor, nor can come upon the settler himself to compensate the City Key Trust for the loss. However, the settlement must be purely voluntary and not founded on valuable consideration at all, for the court does not look at the quantum of consideration, and where the settlement is purely voluntary, the trust will be executed by the court until the estate is actually sold, and the authority and the author of the settlement, if he contract for the sale, cannot himself take proceedings to enforce specific performance, though the purchaser may do so, and though the settler himself may defeat the trust by subsequent sale, the heir or devisees of the settler has no such power. And where a voluntary settlement is made of land subject to the existing mortgage, and the property is sold by the mortgagee under the power of sale, The settlement is not thereby defeated as to the surplus proceeds of the sale after satisfying the mortgage, but chattels personal, and in this respect they differ from chattels real, are not within the statute 27 Elizabeth section 4 relating to the purchasers, and therefore a voluntary settlement of chattels personal cannot be defeated by a subsequent sale. But voluntary deeds may acquire the validity of, by matter of ex post facto, by a sale or mortgage by the volunteer on footing of the voluntary deed, and the doctrine has been extended to the disposition of valuable consideration of the equitable interest. 13 Elizabeth section 5. A voluntary settlement, whether of real or personal estate, may be defeated by the operation of 13 Elizabeth section 5, which makes void all instruments by which creditors, quote, are or shall be in any way disturbed, hindered, delayed, or defrauded, unquote. But such instruments are as made only good consideration a bona fide are accepted. Now, deeds invalid against creditors. Upon the construction of this statute, it has been held that where the settlor was insolvent at the time or subsequently indebted, or the object of defeating creditors may be inferred from a person settling the whole property, real and personal, and so depriving himself of the means of paying an existing debt, the voluntary deed, though supported by a meritorious consideration of providing for his wife or child, and though made in persistence or pursuance of a verbal and antenuptial promise, and though it was a settlement of the purchase money or of an annuity in lieu of purchase money upon sale, is fraudulent as against creditor, though only general creditors without any lien or creditors under voluntary post obit bond. But a deed is not impeachable merely because it comprises the whole of a person's property, or merely because it's voluntary, and although it be on the face of it voluntary, it may be shewn that the extrinsic evidence to be founded upon valuable consideration or to have otherwise bona fide. And on the other hand, the deed, though it was founded on valuable consideration, even in consideration of marriage, may, if it was executed for the purpose of defrauding creditors, be declared to be void. Page 108, 22, section Valid Deeds. If the settler was solvent at the time or was indebted only to the original course as of current expenses which had the means of paying, or not subsequently indebted, or in a sum of considerable amount but adequately secured by a mortgage, which the settler's other property was amply sufficient to meet and the settlement was bona fide, the deed could not be impeached. The indebtedness of the party at the time is only one circumstance of evidence upon the question of fraud, and whether all the circumstances the court may see that no fraud was intended or can be presumed. On the other hand, though the settler was perfectly solvent at the time, yet if he executed the settlement with view of withdrawing the bulk of his property from the reach of his creditors in the event of insolvency, which in his contemplation, as when a person about to embark in a hazardous business makes a settlement on his wife and family to guard against the consequences, the settlement is void. 23. What creditors can set aside the deed? If it can be proved that the settler contemplated, in fact, a fraud upon the subsequent creditors, the deed can no doubt be set aside at their instance, though the settler has not intended that the date of the deed or the deeds or the debts which did exist have since been paid. But where fraud is merely presumed from the want of consideration and the indebtedness of the party, the settlement is deemed fraudulent only as against those creditors who were such at the date of the settlement, and if the creditors have since satisfied the intention of defrauding them is rebutted. But when the deed has once been set aside as fraudulent against the creditor who was such at the time, other subsequent creditors are allowed to come in pro rata, and as subsequent creditors have this equity, they may themselves, though it thus was formerly doubted, institute proceedings to set aside the deed so long as the debt incurred at the date of the deed remains unsatisfied, and where the subsequent creditor proves that such a debt to be still in existence but does not show the insolvency or subsequent indebtedness of the settler at the date of the deed, the court in its discretion may direct an inquiry. The mere abstaining from the suing of a period less than required to raise a bar under the statute of limitations, as for 10 years, will not prevent the creditors from setting aside the deed. 24, where the settlements of stock, and within 13 Elizabeth, Section 5, it was formerly held that settlements of stock, policies of insurance, etc., which were not liable to be taken in execution at the suit of the creditor, were exempt from the operations of the Act, and therefore that settlement of them could not be defeated. But now that by First and Second Victoria, Section 110, which interests are liable to the execution or to be charged by a judge's order, the distinction must be considered as obsolete. 25, bankruptcy. Under the Bankruptcy Act of 1883, a fraudulent conveyance of a person's property or any part thereafter is an act of bankruptcy. As also is any conveyance of property which would be void as frequent preference. And a voluntary settlement is void against the trustee in bankruptcy if the settler become bankrupt within 2 years, and if the settler become bankrupt within 10 years, it is void, unless it can be shown that he was solvent at the time without the aid of property comprised in the settlement and the interest of the settler in the settlement property passed to the trustee of the settlement on the execution thereof. 26, settlement of future property on marriage. Under the Bankruptcy Act 1883, a covenant or contract made in consideration of marriage for the future settlement of the settler's wife or children and of any property wherein he had not had the date of the marriage, any estate or interest, and not being property of the wife, is on his becoming bankrupt before the property is actually transferred pursuant to the conveyance or contract, void against the trustee in the bankruptcy. 27, whether a court of equity will enforce specific performance of agreements under seal where there is no valuable consideration. As every agreement under hand and seal carries a considerable consideration upon the face of it and will support in an action at law, the inference is not unfrequently been drawn that equity in such a case, though the trust not be perfectly created, will specifically execute the contract in favor of volunteers, but equity never enforced a covenant to stand seized to the use of a stranger in blood, and if we examine the authorities, we shall find there is very little ground in support of the position, and it is now well settled that a voluntary covenant, notwithstanding the solemnity of the seal, will not be specifically executed. 28, meritorious consideration. It has been sometimes supported that where the trust is imperfectly created, yet the court, without proof of valuable consideration, will act upon meritorious consideration as payment of debts or provisions for wife or child. 29. Agreement founded thereon not enforced against the settler. After much conflict of authority, it may now be considered as settled that an agreement founded on meritorious consideration will not be executed as against the settler himself. Number 30, how far enforced as against parties claiming under him. As regards parties claiming under the settler, it was always admitted that had the settler sold the estate or become indebted, the equity of the Steady Key Trust claiming on the ground of meritorious consideration would not bind a purchaser or creditors. But if he subsequently made a voluntary settlement or died without disposing of the estate by his acts inter vivos, then the old cases were that the equity would detach as against the volunteers under the settlement, a divisee or legatee, the heirs at law or next of kin, with, however, the savings clause, that the court would not enforce it even as against the classes of persons, where they too could plead meritorious consideration, as if they were children of the settler, without a previous inquiry by the master, whether they had an adequate provision independently of the estate. At the present date, however, there is it is convinced that even as against volunteers claiming of the settler with or without an adequate provision, a voluntary agreement with under seal or not cannot be enforced on the mere grounds of meritorious consideration. Number 31, no trust unless there be an intention to create one. It is obviously essential to the creation of the trust that there should be an intention of creating a trust, and therefore upon a consideration of all the circumstances, the court is of opinion that the settlor did not mean to create a trust. The court will not impute a trust where none in fact was contemplated. Field versus Lonsdale. Thus, where a person having deposited in the savings bank as much money as in his own name as the rules allowed, deposit a further sum in his name as trustee for his sister, but without making any communications to her, and it appeared that he made such deposit with a view of evading the rules of the bank and not to benefit his sister. And by the act of Parliament, he retained the control of the fund. The court held that no trust was created. So if a person endorsed and handed over promissory notes with the intention of making a testamentary disposition, the transaction does not create a trust inter vivos. Money scrivener, next, section 32. As the business of the money scrivener is now almost obsolete, and looking for and procuring investments with the money of clients on land secured is now commonly transacted by solicitors, in the sum of money to be placed by a client in the hands of the solicitor for investment, and a mere deposit will not per se create a relation of trustee and city key trust between the solicitor and the client. 33. Special credit. Special. A letter of advice that a special credit for a particular sum has been opened with a person writing the letter in favor of the person to whom the letter is sent, and that it will be paid ratably as certain goods are delivered upon receipt of certificates of reception from the goods, will not of itself constitute an equitable assignment or a specific appropriation of that sum so as to create a trust. Okay, we'll stop there and we'll pick up next time on Chapter 7 of the object proposed by the trust, page 115. So we'll open it up for some questions.
All right, so Chapter 7, 115.
Yep. I'll put my little red dot there so I can remember. I forgot to do that.
Folks, if you got a question, hit star right on your phone, and I'll go ahead and unmute you. First one, Hackfire. You've been unmuted. Go ahead with your question.
Hey, you guys. Glad to be back. Hey, Christian, I got my question is this right here. If you were me and you were going before the court concerning the discharge of the property, okay, the promissory note or the DOE, whichever one it is.
You're kind of garbled. I'm having a time understanding you.
Can you hear me now?
Yeah, it could be a little better. Try it again.
Okay, I'm moving. So, if you were me, and you have issued a promissory or a BOE for the discharge of property, you go in. If you're going to be the trustee, how would you defend that? And if you are going to be the beneficiary, how are you going to defend that? What would you say each person duties there, what they did to discharge the property? Because I know we talked about last time before I went to Canada, we talked about, okay, you issued the note, they need to sign it, endorse it. They haven't endorsed it. So, technically, I can't pay the bill.
Let me see if I got this straight. So you issued a promissory note as payment for
either one, promissory, BOE, either one that you issued to discharge the mortgage.
You're the trustee, you said?
Yeah. Okay. If I'm going in as if you're appearing as the trustee, what are you going to say concerning that? If you are appearing as the beneficiary, what would you say? Okay, if you're the beneficiary or the trustee, for instance, I say, okay, well, you're making me the trustee, judge. This is what I get concerning the trust or issuing of the payment. You're looking at two different entities here that you're selecting to play.
Yeah, two separate entities and two separate scenarios there.
Okay. Well, I'm asking Kristen. Okay, you said concerning your car, your house, or whatever. You're coming in as the beneficiary. How are you going to defend? What are you going to say?
If I was coming in as the beneficiary in a hypothetical case like that, then I would say that, after I claimed and proved the trust, now I've got standing as beneficiary to bring a claim against the trustee, and obviously the trustee was probably going to say be them. And since if I'm beneficiary, I should have gotten a disbursement or a payment, and I didn't receive the payment. The Court of Equity is going to assume that trustee didn't make the payment, and they're going to want to know when they're going to make the payment.
Okay.
Now, the other scenario, if I'm going to come in as trustee, once I claim and prove the trust, and then I have the office and standing of trustee of that trust, I have the ability to make the payment. Now I could make a payment. Or I could take and claim that, well, I can talk about this in chambers, say that this was a discretionary trust and I didn't have the right to pay the beneficiary, make a disbursement, because the creditors would have jumped on the beneficiary's assets as soon as I gave it, which would be a defeat of the purpose of the trust, and I would breach the trust myself, and legally I can't do that.
Right, and you've said that repeatedly. Now, let me go back to something here, the scenario of after you have proven the trust, as you've been teaching us. Now, am I to say, okay, as the grantor, as which is equal probably to, in my concept, to the secured party creditor, I have security agreement with the straw man. Okay, I have a whole harmless agreement. So as the beneficiary, you're the grantor, the guy that issued the declaration and the notice. I'm held harmless. You don't come to me demanding $30,000, $50,000, $50,000. Is that correct? Is that a good concept?
Well, that's another situation there. Upon the special deposit for the notes and that,
right.
That should have been the extinguishment of the debt right there as a special deposit with the purpose that I was specified that was, or to function as a payment like a debtor-creditor side, but it's not a payment, it's extinguishment of the debt.
Okay.
The title of the debt has been merged with the title to the asset.
Okay. So with the whole harmless in chambers, like we were saying about the 28 to 91, the trademark secret. Your Honor, we need to take this in chambers. You can view these documents in chambers. That's ideal, et cetera, as to my standing as the grantor or the beneficiary of the trust.
Yeah, we're going to have to one scenario over the other.
Okay. So basically it'll be up to me to decide that.
You're going to have to play either the trustee role or you're going to have to play the beneficiary role one way or the other. And then that would determine, how you're going to play this out. It sounds like you may be confusing maybe a little bit of both of them and mixing in the debtor-creditor stuff about secured party creditor and things.
Okay. I got that. I'll be recording it to get online and get a copy of this tape tonight. So that answered my question. I'll proceed from there. I appreciate it.
All right. Thank you.
You're welcome. Thank you, Chris.
It was a little hard to understand you because of the line there, but anyway, did the best we could.
I'm sorry, Christian. I'm driving cross country.
All right, next caller, MN Rez. You've been unmuted. Go ahead with your question, please.
Yeah, this is Minrez, Mark from Minnesota. Good evening, Christian. 2 questions, if I may. I was listening to a tape from January this year, and you were talking with, I believe, Chris from California about one of the Patriots movement, his procedures as far as financing statements and UCC3s, and his whole process with negative averments and such. And I'm wondering, because I'm a converted patriot, I still have American blood pumping in my veins, but I'd like to ask if, now, following this individual's process in the Patriot movement, all the way to filing the UCCs and filing everything with Geithner's office, in order to move forward with expressing all my trusts, is this going to be an interference with me, or should I negate that UCC 1 and 3 that I filed through that process? Does that make sense?
I don't remember what the 1 and 3 was applying to under Chris, what he mentioned. Could you?
Well, the conversation that you had with Chris was he did a 3-day seminar of this individual's, and I mean, I could name his name, but I don't know if that's appropriate on the air. Well-known patriot out there, well-known, involved in the bringing back the Republic. You don't have to mention his name, but what was kind of the process? His process is a negative averment process, and you file birth certificate bonds, indemnity bonds, and such through Geithner's office, Secretary of Treasury office. And in that process, you file a UCC 1, and I'm a convert from the debtor creditor scenarios into trust. I'm totally convinced that you have this nailed down. As far as expecting any consistent remedy through trust. And I'm in the process with others in my group in Minnesota here to express these trusts with the SS5 and birth certificate and all that. But I'm ready to file my UCCs, but I have that UCC that I used through this other individual's program already filed, and I don't know if that's going to interfere with my final expression of the trust when I get all the way to the IMF file with the IRS.
Are working on the same focus? Two separate processes doing this, trying to achieve the same results. Is that what you mean?
Similar, yeah, I think so, because the original UCC that I filed was totally under debtor-creditor procedures. I'll put it that way.
What you want to know is that the process you started on a debtor-creditor is going to interfere with the trust procedure affecting the same property?
Exactly. There's a security agreement annotated in the UCC 1 and quite a few other documents.
Kind of like mixing apples and oranges, two different. I can't give you an outcome how I think that might turn out.
Yeah, I've been vacillating on it really long and hard, and again, I'm converting from the debtor-creditor world to this world of trust that I feel by the grace of God you were brought to be, and I'm really happy to be involved. So I can make my own decision on that, but it does make sense that it sounds like apples and oranges, and I think I better make it all apples and apples. So that's something I'll consider.
But you could.
Go ahead.
I suggest what you could do, if this is like a lien situation, you could probably put the lien into a trust, a separate trust.
Mm-hmm.
Once you got the lien perfected, put it into a separate trust.
Yeah, I think that would be the practical thing to do and follow the trust path. And I really want to stay away from the debtor-creditor thing. I'm seeing too much. There's no consistency in those processes. There's no.
Now you could. That would, in effect, once you deposit the lien into the trust, a new trust, now you have a separate trust that you could come at them with, and now you've got two trusts that are coming at them. So you've upgraded it from a debtor-creditor, and you put it into trust and let the trust enforce the lien.
Well, that's an avenue I didn't consider. I appreciate that. Second question would be now, along with expressing the trusts with SS5 and birth certificate, I heard another scenario where you talked about, in my behalf, I submitted my birth certificate application through notary presentment, certified mail, and I believe I have that to where I can prove that I did file as grantor. My Social Security SS5 application, I did not send it through the notarial process. I just mailed it in with documentations, and they mailed it back. But I did keep the original application that I signed for the card, and I did receive the card. But my question is, and through listening to you describing the notary processes, is that we should probably get the notary presentment, whether it be in person with the notary or through a notary presentment certified or registered mail scenario.
Yes, you could also use the 1s and the 3s and the counties to create the records also.
So my question, am I okay with just, they did send me my card back, I sign it off as beneficiary on the card, but the original, if the judge if we're in chambers and the judge looks at it and says, I don't see any trust here, just because you say this is an original application as grantor, how do I know that you sent that to the to the Social Security people? They don't have a notary presentment on it, is my point.
Do you have a certified mail or something? Or a witness?
No. I better do that. I better do it again.
Yeah, I'd want to create some kind of record that I had some kind of proof that I could say this was notice I did that.
Yeah, I heard your discussions about it, and I thought, boy, I didn't do that. So, all right. Well, thank you again, Christian, and kudos to you and your efforts. I know you work as hard as a human being can possibly work in this respect, and you've got a lot of good followers all over the country, and we have a nice group in the Twin City, Minnesota area that you've been in contact with, and we appreciate your help greatly.
Okay. You've got the other shows on Monday, Tuesday, and Wednesday and Saturday?
Yes, we're trying to coordinate our group to, there's too much for one person to follow, so we're trying to coordinate our group to get recordings and listen to them and take notes on them and bring that into us. We meet once or twice a week almost, and it's a little dissembled right now, but we're working on getting it a lot more organized so that we can pick off all your calls and get the meat of it brought into the center of our meetings and continue to study and work in the same direction with your guidance. And we're really appreciative of what you've done.
Okay, well, I'm glad to have you on the calls.
All right, well, that's all I've got, Christian. I thank you so much. If I come up with another question, I'll raise my hand again.
Okay, great. Thank you.
Thanks, Mark.
Good night. Good night.
Hey, folks, got a question? Star 8 on your phone. Live guy's got a question. Go ahead, you've been unmuted.
Hi, Christian.
Hi, go ahead.
Hi, this is Dominic from Ireland. How you doing?
Good. How's you been?
I've been good, actually. I've been good, yeah. I've just recently joined back on the trust study. I've been away for a few weeks. But good to be back and good to be on the calls again. I just want to run by a scenario by you, if that's okay. This situation is there's 2 credit cards and 1 overdraft facility with a specific lender, and the lenders have failed to respond to any of my requests under debtor creditor. And what's happened now is that the lender has given the 3 accounts to DCA, which is a team of lawyers here in Ireland, and they have issued me court papers. So my question to you is should I claim, prove, and express the trust for each of those accounts and send separate packs to the CFO and copy the court in on them? Or should I claim, express, and prove the trust and use the court papers as a trust res and establish the DCAs as trustees and copy the court and also? What way would you do it?
You might want to incorporate all 3 accounts are handled by one attorney firm?
Yeah, they're all with one lender, but one attorney firm has sent me court papers, yeah, for all 3.
Okay, you might want to just maybe go after the one as a case incorporating all 3 accounts and turn that into the trust.
Okay, so deal with the DCA specifically. So.
Yeah, I think
okay.
You could do it either way, really. You could treat each one separately, or you could incorporate them all into the case.
Okay, that sounds. Yeah, I was thinking I could do it actually as well to the lender. Just send off.
Yeah.
Put the 3 application forms. Sorry.
Yeah. It may be a little bit better to actually hit the principal, which would be the lender. But
yeah.
you go either way, I'd say.
Yeah. So put the 3 application forms into a specific trust, and send the pack off with my UCC ones and the formation of the trust to the CFO. Yeah, and copy the court in as well. Possibly I think it would be good to make the court aware that a trust is established as soon as possible.
Yeah, I'm kind of leaning towards the 3 separate ones and go after them 3 separate ones.
Okay, that's fantastic.
We'll go back to the original principle.
Go back to the original, yeah. Now we have these forms here on our court website here in Ireland, and I'm sure it's similar to the UK as well. It might be similar to you guys. They're a form of a summons, and they're called civil bills. But they have a form called an equity civil bill, and I was reading today that deals specifically with trust-related issues. So I was just wondering, is there any concern, or would you see any concern in using their court forms to basically, go for an equity hearing if the trustee fails to perform?
Yeah, your situation may be a little different from over here. Because they combined them into one form and actually ruled through equity. Now we've got a private side of the court and a public side of the court. But I think maybe in your case, maybe that doesn't exist there, and you maybe get right into equity, right in through the court by applying to that equity court.
Yeah. I think it seems to be the case that because.
Is it different from?
Sorry?
Is it a different court in Chancery?
I think they're the same. I think they're the same here, the equity court and the Chancery. I think they're the same.
Yeah, Chancery is the same as equity, yeah. But I mean, the court that you're in, that they're coming at you, is it the Chancery court?
No, it's even though it's the same kind of building. It's not. No, it's not. It's not the Chancery court. No, they're coming at me with statute, obviously.
Well, I'm thinking, where do you get your equity from? Do you have to go directly into Chancery, which would be equity?
Yes.
So you issue a counterclaim in Court of Chancery?
Yeah, exactly. Yeah. It's called it's called an equity civil bill, so I suppose it would be a counterclaim, yeah. It would be counterclaim form, but strictly in equity, like.
Right. Yeah,
I was reading.
Yeah, I'm not up on how your country's laws are set up there for the court setup. But I think it might be two separate courts, the one that they're coming at you with, but then to get into equity, like you mentioned, you might have to go to a court of equity or a court of chancery to get in there.
Yeah.
Would that it's the other court then in there? Would that be like a transfer into the other court?
I'm not too sure. I'd probably have to ring the court actually myself maybe next week and find out exactly what would be needed to get into a court of equity. It seems as if that form would be perfect for what I need, but I'm probably better off just checking it out because I'm not sure exactly.
What was it? What did you say? Equity bill?
An equity civil bill.
Civil bill and equity?
Yeah.
Yeah, that sounds like it accesses equity.
Yeah, because it's tied directly into the Trustee Act of 1893 in the Irish system here, and the equity civil bill only deals specifically with trust-related issues.
Does your country have like what happened here in 33? I think it was in 1938 with the Erie versus Tompkins case. Were actually in Federal Rules of Evidence, they combined, it says in Rule 1 and 2, they've combined everything into one form of action. Is there any kind of similar act in your country that has done the same thing?
Good question. I don't know. I'd have to check that out, Christian. I'd have to check that out.
Yeah, so I know you have to get in to enforce an equitable interest of the trust through equity, but I can't answer, on your setup there as how to get into equity as I could here. Yeah,
that's okay. That's cool. Again, I can just phone the court in and I can ask them. But it does seem as if this equity civil bill could be straight away in, But I think regardless, I think I'd be in agreement there with. Go back to the original lender and deal with each account separately, and copy the court in all my correspondences as well, just to make them aware that there is a trust in place, and take it from there.
Mm-hmm.
Yeah, that sounds good to me, Christian.
All right. Anything else?
Okay. Not yet. If I have another question, I'll come back on to you.
Okay. All right. Thanks. Appreciate it.
Thanks, Christian.
Thanks,
Thank you.
Tom.
Thanks, Matt.
Yep. Anybody else got a question for Christian? Star 8 on your phone, folks. And we'll get you unmuted here. (9:30) Eastern Time. Been going an hour and a half tonight.
Well, there was some pretty good, interesting stuff of what I read there, especially towards the end.
Yeah.
And especially the one I said mentioned, go back over there and review that. So.
Yep.
We got some of the dried stuff out of the way. Last week was kind of cut and dry, but this week was a little more interesting, really in details and specific stuff. So you probably want to go back and review that. And I know that's what we'll be probably doing later. Once we get through our read of this whole thing, then we'll come back in and we'll start dissecting certain sections.
Looks like we got a question from non-member. You've been unmuted. Go ahead.
Hiya, good evening, Christian.
Hi.
My name's Harry. I'm speaking from Surrey in England. I caught part of your show on Monday night. Unfortunately, time constraints were that I couldn't actually get round to asking a question. I'm fairly new to trusts, actually, and have been going through your stuff recently. I just really wanted to get a pointer and a feel as to which direction I should be going at. My scenario is at the moment that I've had few properties which have been repossessed, or maybe you call it foreclosed on, and we have another scenario where there are LPA receivers which actually move into some properties, so they take over control of properties which they eventually sell on. The upshot of which is that it leaves, when they do sell, shortfalls. Now, the shortfalls are unsecured debts because the original debt is against properties. And I'm just wondering, with the trust scenario and being fairly new, which way I should start thinking of approaching these, because the actual debt that they're talking about, or the shortfall, is quite a large amount. We're talking about sort of coming onto 7 figures.
So all the properties have been already foreclosed on?
Well, I'm just thinking of the ones that have been, not the ones that I currently have, but it's more that they are starting to chase and trying to get me back into novation of contract. And I'm just really, originally I was planning to maybe do some liquidations and possibly test promissory notes on the shortfalls, but then, like I said, I come across the equity scenario and your NTT technology, and then I started thinking, well, I wonder what would be the best way to actually approach it now. And so, because I'm fairly new, I'm obviously not confident enough to, at this moment of time, take them on from that point of view. And I just thought, if I could find a pathway that I could get the scenario, so I know I'm not going off at the wrong tangent, basically.
Right. Well, I would say on the properties that might not be any kind of actions coming up against them, if there's any subject that they may get lost in the future, I'd start thinking about very seriously putting them into trust for asset protection.
Now, you're talking about the current ones that I have, or obviously
the
only ones I can put
that you have already. That if they're not in there any kind of action, they're foreclosing on them. I would, to keep them safe, I'd maybe think about transferring them into a trust, private trust.
Okay. Now, can you put something into a private trust if there is a perceived debt already actually linked to the title of the property?
Yeah, sure. Inter vivos trust.
Okay, fine. What about the ones which have already been foreclosed on?
Okay, those I would go back and start working on them to reverse everything that was set up as debtor-creditor, which allowed them to foreclose. I'd go back and change that all into trust. And then I would create the records that would enable me to prove a trust. Then I would come back in and treat all that as a special deposit and ask for everything back. And when they don't, that would fall into a breach. And then I would go back and enforce the breach, come back in with using that as a counterclaim that was the thing that paid the payments, and they took the whole properties under a cause of action being, say, conversion. They did a conversion on all the properties when they shouldn't have.
Right. Okay, that sounds like I've got my head around that. Okay, I will explore that avenue a bit further. Like I said, I am fairly newish to this. Any of your particular materials that would be ideally suited for somebody like me that's fairly new on this? I mean, like I said, I've got a lot of the audios. It is a question of actually going through them all.
Yeah, that's where I would check the past audios, go through all those, especially starting in 11/7 of 2009 and forward.
Right. Okay, from then on,
yes.
Really. And is that because the ones I've got go back to about, I think, June of last year?
Yeah, the ones that go back any farther than 11 of November of last year are really under the debtor-creditor realm, and we didn't come out officially with NTT until 11/7 of 2010, or 2009, excuse me.
Fine.
Everything forward that date is all NTT and all trust, and I'm completely of abandoned debtor-creditor position.
Sure. Okay, thank you very much indeed, sir, for that. Appreciate your time.
All right, thank you.
Thank you.
Some of the people over there in England, I assume that you're familiar with them over there. They're on the calls also.
Yes, they are on the calls. I have actually contacted one or two. Especially, I mean, it's a lot easier if somebody's going through sort of similar sort of circumstances, so they can actually relate quite a lot to what
Right.
you're going through. If somebody's doing it for something a bit smaller, I know the scenario is pretty similar, but it's not exactly quite the same. So I am trying to hook up with a couple of people that are in a similar sort of pathway.
Right. I'm sure they could point you in directions because they probably know some of the banks do. So.
Okay. Thank you very much indeed.
I gotta talk. Hey, Christian, live guy, Dom's got another question for you.
All right.
Go ahead, Dom.
Hello.
Yes, go ahead.
Hello. Hi, Christine. It's Lawrence from Liverpool.
Hi, how are you?
Forgive me if I'm going over all. I'm very good from you. Hello.
Yes, hello. Go ahead.
Hi. Forgive me if I'm going over old ground, as my trust knowledge is still in its infancy. But I have a question about special deposits.
Sure. Go ahead.
I opened a bank account today. As a special trust deposit. I was hoping you could give me some guidance on what my next course of actions could be.
All right. Did you have a specific purpose that you opened it up with?
Purpose was to place a deposit, special deposit, in the bank to stop my funds from being commingled.
Was there any kind of special agreement that you signed with them or anything?
I went into the bank and I went with Pete and I asked if I could open a new account. I could. Because I'm an existing customer at the bank, the actual process of opening a bank account only took about 2 minutes. And the receptionist, or the bank clerk, she gave me a receipt of the account. Now, I was a little bit confused at this point because I was expecting to get an application form for the account or something along them lines, but it was just a receipt for the account. And the girl just signed it, and I asked, don't I get to sign anything? And she said, well, no, because we've got all your details. This is just a receipt for you, just the information of your account. Up to this point, I haven't mentioned anything about making a special deposit. I just kind of said I just wanted to open an account. At this point, though, I realised I had to kind of show my hand a little bit and told the girl that I wanted to make a special deposit. And obviously, she looked at the letter I was making. So I kind of explained a little bit of what my knowledge of special deposits were. And I said, look, I want to make a special deposit because we're in a banking crisis. I don't want my funds that I put into my account to be commingled with yours. And she didn't know what I was talking about, so she had to go and get a manager. So when she left the room, I took the receipt and wrote on the top, non-negotiable special trust deposit, private between parties, to be held separately for return for my future records. And then on the bottom, I wrote, signed it by Lawrence, grantor, settlor, beneficiary. And on the right, I wrote Stephen Hesper, I think his name was, the CEO of the bank, and placed trustee underneath that. On the bottom, I said, no, just the principal, etc., in equity. And eventually, when the bank manager returned, I already had the document written up and went through the same kind of conversation with the manager, and she was going, look, we don't do this. And I said, well, I think you find that you did it. She said, well, we don't. So, well, look, I need a witness to this. So I brought Pete in. Pete signed as a witness with ellipses. And we continued our discussion a little bit further to the point where I said, look, I've delivered this document to you now. It's been seen by a witness. you've got my instructions. I'm leaving, and I just got up and left her with the res, I suppose, and she was off to go and speak to the legal team. Now, that's where I'm at right now.
Okay. So did you, what was the deposit? Was it like cash or something, or?
No, the deposit was my signature, I suppose. It was me making a deposit of my signature into the savings account that I established. The account was opened without any funds being placed in it.
Okay, I get it.
Now, I'm a bit sketchy on what the next stage would be for me. Unfortunately, I haven't been able to catch up enough on your calls regarding withdrawal, special deposit, and general deposit. Kind of got a general idea, but not a special one. So I'm kind of looking for your guidance, really, on what my next stage would be.
Well, you'd probably want to, say, monetize your signature and have them treat your signature as an equitable asset, and then have them be the vehicle that would do the conversion for you into public credit that you could use. So you're going to take your private equitable credit and convert it into public credit so that you could use, say, in another separate account, and like use that to be transferred over into the other account that you could, say, write checks directly from. Kind of get my meaning?
Kind of get your meaning, yeah. I'm just trying to work out what the mechanics are in terms of they take my signature and place a special deposit, and I instruct the bank as my administrators, trustees, to convert the res into a security, or
yes.
I'm kind of a bit sketchy on what.
Well, not security. Your signature is equitable, and it's on the private side under the special deposit, and you're going to treat your signature as an equitable asset. So tell them to convert your signature, your equitable asset, into public credit, and then deposit that into another account.
What determines the value of the signature? I mean, what kind of public credit are we talking here?
You do.
Okay. Party time. Okay, I see. So then that the credit is taken from my special deposit account and transferred into my public commercial current account. Is that correct?
Yes. You use that one account that you got your signature deposit in as the equitable asset private side trust.
Yeah.
And that is really unlimited.
Ace. Now,
obviously, use the bank as the conversion, because they can do the conversion and convert it into public credit and deposit into some other account that you have.
And because Pete is signed with Ellipsis, I'm going to make Pete co-beneficiary. But obviously, I don't think the bank is just going to roll over and, start giving me public credit. What would be my course of action?
Probably should be doing business with the CFO and the CEO of the bank, really.
Okay.
But now that you've got an account established there, you might want to start going upstairs and negotiating with the people upstairs.
Okay. Would they negotiate with me, though? I mean, I know.
Maybe negotiate is a bad term. I wouldn't say negotiate. You're going to use non-precatory language, and you're going to order them. This is what I want. Okay. I direct you to order my signature, change it from an equitable asset to $50,000 in public credit.
Right.
Deposit it into an existing credit account that I have, which is on the public side now. So they're just going to take it out of that one account, put it in the other account.
Now, can I do this orally, or does this need to be in written form?
You could do it orally, yes. Yeah.
Yeah? Okay. Now,
here's the thing. I don't know about back office banking over there, but probably through the front office is, you got all these tellers that don't know what's what. So you're going to have to somehow get into the back office. And I don't know of anybody more apt to know anything about back office banking than the CFO and the CEO of the bank itself.
Okay. So these are the guys I want to be instructing to do the job?
I would think so, yes. Because maybe the manager, assistant managers, those people might not know anything because they got to go to legal. They're just front office banking, and that's not back office banking.
Well, I should imagine that document was passed around that bank for everyone to have a look at.
Say that again. She was what?
I should imagine that the res that I created today was passed around, the bankers for everybody to look at. It must have been an unusual document for them to receive.
Yeah, right. They're probably having a laugh about that.
Yeah.
Yes.
Yeah. So Christian, if the bank don't want to play ball, right, and they refuse my demands, what's my next course of action?
Breach of trust.
Yeah, so take it straight into Chancery.
Yes. No, there's where you might have to have your instructions in writing, give them an opportunity to cure.
Right, I see. Yeah.
And then when they don't do it, put it in writing. Well, I ordered you to do what was ordered. You didn't do it, so you're in breach of the trust.
Now, in equity, do we have precedent?
Yes, over at laws.
So would the bank be reluctant to enter into equity to prevent a precedent being set?
Well, actually, if they're doing back office banking, that is all equitable. It's all private, and it should be confidential and kept secret, and nothing is disclosed. Nobody's any the wiser. It's really a private agreement between two private parties.
Yeah. So even if I won the case, for example, that would not be, that would not be a precedent, whereas all future claims would follow that, that precedent.
They would probably want to settle out of court before they actually set up a precedent.
Yeah. I'm thinking that.
When you go in, make sure that you say, that everything we talk about here is confidential.
Yeah. Okay. Brilliant, Christian. Thanks for your help. I really appreciate it. A lot of fun. It was a lot of fun. Oh, that's another question I have, Christian.
Go ahead.
Is there anything stopping me from going to a number of banks tomorrow, opening a number of special deposit accounts with numerous banks?
Nothing stopping you. Maybe try something a little bit different.
Just to rub the noses in it. Okay. Christian, thanks a lot for your time and sharing your knowledge. I really appreciate it, and I hope to speak to you again soon with an update.
Okay, thank you.
Thanks very much. Bye now.
Hey, Don, did you also have another question for Christian?
No, I didn't have any further questions yet, Matt.
Okay, great. Just wanted to confirm before I put you back on mute.
Okay, cheers. I appreciate it.
Hey, Mark. Do you have another question?
I do. Thank you. As a matter of fact, I've got a couple, but in regards to expressing the trust up to the IMF level, we've had discussions in our group about passports and driver's licenses. Being that we're signed on with our current passports and driver's licenses as debtor creditor in the past. Now, I thought I heard some. That's not me. We have a new one on the line there. The discussion that we had was when we renew our passports, is there a known process to express the trust in those two particular areas, or is there even a need for it, being that they're just the utilities for our vehicle to transport throughout international air and seas? Does that make sense?
Are you aware of that we did about 3 weeks ago on 5A came out with a withdrawal and a redeposit to correct the general deposit error that we've made?
I didn't catch that one. Do you have the date on that?
That was 5/8/2010.
5/8.
Also 5/10/2010.
Okay, and those two will cover that particular subject?
Yes. Also, I think it was, what's today? We went over that again, I think, on Monday and Tuesday a little bit, too.
And then I have a very good friend that is an international commercial pilot, and he really loves his job. In the going to the pinnacle or the top of the mountain, once we get to the IMF level and clear up our personal issues and such, is it a commingling if he would continue to remain a international commercial pilot?
His straw man would probably, what I plan to do was to terminate the straw man and that way sever all business ties with any commercial entities at all.
Exactly.
And
that was
form a new entity that's going to reface him back into commerce, but is never going to do a business or trade, so therefore it can't be an employee of the United States or any other entity.
Right. So he'd have to start a nonprofit foundation or organization and then buy his own citation or something, huh?
Yeah, something that you're not going to generate some kind of income that's going to be taxable and throw you back in under a business, U.S. business or trade.
Boy, this is a fine line that we're going to be walking when we get all of these trusts expressed.
Really, none of us have to work for Federal Reserve notes ever again. All we just turn into are just consumers consuming the product that we need, and we're not doing a business or trade, and we're not connecting ourselves back in and making ourselves U.S. citizens again.
Well,
so yeah, that's a line to be walking.
That's a very, very thrilling concept.
For us doing that.
It's such a thrilling concept, and we kick that around in our meetings here in Minnesota all the time. And we're trying to get into some private bankers and such. And as you know, it's not an easy task. But I don't know that I'm hoping we're ready. There's a bunch of us that are completing the administrative processes on expressing all these trusts. Mm-hmm. And we are communicating with some bankers, and we're running into some knowledge. Mostly we're running into either they're ignorant of what's going on or they're not willing to put it on the table at this point. I don't know. Maybe
domestic banks?
Yeah. I think they're FDIC bankers at this point. They're federal.
Yeah, you might have more luck with international.
I just, if I may, I have some individuals that I've dealt with in the past that were dealing in very, very large numbers in private paper, dealing with the top 25 banks. They were dealing in some really large amounts, money that most people would never dream of having, and I still have access to them, but I don't know how to approach them. And I've talked about this with our group mentor, and we're trying to strategize a way to approach these guys, because if you approach them in the wrong way, the phone will be hung up on you, and the relationship will probably end. They're that touchy.
Mm-hmm. I would throw it out there. Are they in the private banking realm, or do they do back office banking? And
well, I know one. I know one is a securities trader. He's connected over into the European banks, and he trades paper. He's a conduit, and they're hard to find. If you had a very large,
does he have a class of designation? What kind of trader is he? Does he have a class designation trader?
Yeah, he's a security and exchange trader, I believe.
Okay, does he have like a G series sequence trading?
I believe he does. I don't know exactly. I didn't inquire on that, but I know he does, because he's directly connected over to the European banks.
Yeah, ask him what level of trading license does he have.
Okay.
B12, G11, G13, something like that.
That makes sense. Then this other individual I know
has access to the information. Otherwise, they're probably just doing public side trading.
I think that might be what this individual is doing. I had another, and I'm just looking for a little more input. I have another friend that I became acquainted with that he had his own company with a couple of his family members, and they were private individuals actually investing in very large sums of paper in the billions.
Right.
And they were doing it as private, I believe, private investors, or they may have been brokering this stuff. So I don't know that they were licensed. They were just
do a licensed trade is the higher the sequence, especially like a G13, it's got to be on the private side, where otherwise the lower ones are just doing public trades.
Yeah. So if I had now the second individual that I had mentioned, he had gotten an extremely one of the major banks in the U.S. Convinced him to part ways with the family members in the private business that they were doing, and they put him on the payroll, and he had to go through months and a lot of training. I don't remember exactly how long it was. It was last year. In order to get his license to work in the higher echelons in that banking system. I think he would probably be my better contact.
Yeah, give him a try, see what he might be able to point you in a direction.
Yeah, I'm wondering if you could relay to Victor, and I think you're familiar with Victor in Minnesota. I don't know if you have some knowledge, or I don't believe we can get into the conversation on the air here, but if you have somebody with the knowledge to contact somebody that's that level of banking in order to try to get some assistance from those folks or from him to give us guidance on putting this private stuff together. I admit I don't have that expertise or knowledge to approach him with that.
Right.
My business with him earlier a year or two ago, a year and a half ago, was I was brokering paper and gems and such. So I really don't have the banking knowledge to really sit down and talk turkey with this individual, and I would like to have somebody, before I open up the communications with him, I would like somebody that's knowledgeable to set a format for the conversation.
Mm-hmm.
If that could work. Something to think about, Mr. Christian. I think that's all I've got for tonight. You've been most gracious once again. I thank you, and I'll get off the line here and let somebody else have a shot at you.
Okay. Well, one thing I had to maybe add to that was that we tend to sidestep all this other stuff, and we'll do that by actually having the Treasury do all this for us.
Mm-hmm.
We won't have to worry about going through all these under banks that give us a hard time and everything. It'll just come directly out of the Treasury.
Well, I would love to follow the breadcrumbs to the pinnacle with you. We will be. There's no question about it. But I know we feel like it's moving slow, but then when I look behind and I look 2 or 3 years ago when I first got on this journey as a dedicated patriot, it was it's been a long road of how you call rabbit trails, and I really think that we've gotten onto a path that's going to give us consistent, persistent performance.
So do I. That's why I'm here.
Yeah, you are definitely, I think there's some divine intervention in this whole process that you're bringing forward. And, I look at the call list over here and I think, we've got 300 million people in this great country of ours, and somehow we need to do better than we are. And I'm just a novice in comparison to the efforts that you've put into this whole trust education, and but I'm digging in. I just can't get enough fast enough. But I guess diligence will pay.
Yeah.
So
before there's no fine wine before it's time.
Boy, and I have to thank the Lord above. He's given me a lot of patience, and he's given me more, because I'm that personality that I want it all and I want it now. But. We Minnesotans appreciate all of the hard effort that you put in, and we're tracking you like a hawk, my friend. So we'll stay in close touch.
Okay.
Thank you, and good night once again.
Wow. Thanks again.
Yep. Good night.
Thanks, Mark.
Yes, sir.
All right, West Maryland. You have been unmuted. Go ahead with your question.
Hi, Christian, this is Eric. I was wondering what percentage of cases that you've seen where homes have already gone through the foreclosure sale, and earlier there was a call where you said, go ahead and claim the trust and express the trust, and then go back and come to do their duty and then get them on breach of trust. How many times? What percentage would you say that they've actually had a successful remedy if a house has already gone through the foreclosure sale? And for those that have actually seen a remedy that have gone through the foreclosure sale, how far after the foreclosure sale do they typically see that remedy? Or is there a cutoff time where, okay, it's definitely too late, or, hey, you want to get in before this certain number of days?
Well, to answer the question, percentage, really, I'm not really moving forward too much. I'm developing a foundation, and I'm not stressing anybody to really move forward. And I'm not keeping track of successes, really. Number one, this technology is too new to even measure any kind of success. There are a lot of individuals doing different things on what they hear on the calls that I'm not even privy to knowing what they're doing.
Okay. Yeah.
I have no way of measuring it. So I think it's a little premature to measure this in any way, shape, or form because it's too new.
So would you also then agree that, one shouldn't try to go after a number of remedies to try to measure because it is too new?
Well, I think people should be concentrating on building a solid foundation of trust knowledge first before they attempt anything.
Absolutely
they should
agree.
really understand what they're doing first because, it's like putting the cart before the horse. You can't push the cart. You got to pull the cart with a horse.
trust knowledge in general, meaning Gilbert's and Lewin, or trust knowledge meaning NTT and and Lewin and Gilbert's and everything else that could be learned?
Yeah, we're using the Gilbert's as a black trust, as statutory trust-wise, to show you in relation. If I teach you the black, you'll know the white by sight. So
right.
We're going in the white and the Lewin here. And NTT is based on, an offensive moves more than so that an asset protection. So it's just the way that trust is used.
Right. So when you say that, one should definitely up their knowledge and make sure they understand everything regarding trust, is it just understanding the Lewin and understanding the NTT and how the NTT is applied, or is there more to it that should be understood before really stepping out there and making moves?
I don't know exactly how to answer that. It's like the size of the building is going to be determined by the amount of time spent on the foundation. And I'm
very true.
a doctrinal type person before I step out in action to do the practical application of it.
Okay, I understand.
I'd like to see us get a solid footing first, and then once we got a solid footing, and how do you know you got a solid footing?
That was going to be the next question. Woo!
Well, you can answer your own questions.
I heard you say that before. So I would think that in order for one to really know the answer to one's question, in addition to all the prep and training, one would have to step out and learn from stepping out, or learn from others stepping out.
Well, that you can learn from stepping out, putting things into practical applications, but that could be a very dangerous and very hurtful, because you're subject yourself, opening yourself up to things you didn't see before. And maybe if you had waited a little while longer, you would have saw that from a different angle, and you could have seen it coming.
I agree.
Now, when is that? That's almost something that everybody's individually going to have to answer themselves. I can't answer that for you.
Right.
Some people are stuck between a rock and a hard place, and they're willing to throw anything in just to save their asses, which is kind of foolish, because you may get yourself in worse trouble than you bargained for.
Exactly.
Because due to your own ignorance, you just don't know what to say and when to say it, and they just hammer you. So that could be detrimental. I'm not saying people don't try it, but be very aware that you're the ones putting the signatures on the lines, and don't come crying to me because it didn't work.
No, absolutely right. I mean, because I've seen a group of people, go forward and try their hand, and you're right. It's brand new. These guys are like less than 6 months into it, and so far so good. But you never know, what's around the corner, and you don't want to necessarily follow in suit unless you have a full understanding of what could be around the corner from those who've already gone. If that's what you're looking at as a model.
Right.
So I appreciate everything. Thank you.
All right. You had some good points there.
Thank you.
Okay. Livewater's got a question. Go ahead, you've been unmuted.
Hello?
Hello.
Can you hear me?
Yeah, I'm good.
I had a question about the withdrawing of the general deposit.
Okay. Background noise there.
Yeah, I know. I don't know what to do here. Is that better?
Yeah, way better.
Okay, thanks. Christian, in in reference to a mortgage foreclosure scenario, actually in reference to, even more specifically, a closing of escrow on the day of the event, it appears that the party that's actually making the general deposit, when I think about it deeply, is not I. It is the trustee that the so-called alleged banker beneficiary has at the helm of the escrow. And really, the trustee is supposed to be competent and know what they're doing, and in this case is actually appears to me to be the party that is incompetent that is making this general deposit. So when I think about it, I think that there is a trust between myself and the beneficiary, the bank, and the trustee, the title company, or whom possibly might be the escrow company or another party. So I guess my question is, based on that basis, would it be prudent to consider terminating that trust and just treating the special deposit as the regular trust that you've got the indenture for, with the beneficiary in the escrow where they're getting the promissory note from?
Yeah, I would say the trustee. We're getting some feedback.
Okay, let me sign off. Go ahead.
The trustee that you is there. He's there because now you realize. So we're getting back yet.
Okay, I muted them all. Go ahead, Christian.
Okay. Yeah, the trustee is. There's a trust on the private side because you came to the realization that it was a trust, although it never has been expressed as a trust. Therefore, on the public side, there is no existence of a trust. So, yeah, there is a trustee when you come to the realization that this was a trust, but then there's no public recognition of this being a trust because you never expressed it. Now, once you realize that, you come back and correct all this mess. You could revoke the trusteeship because you gave them a power of attorney and you didn't know what they were doing. So really, you were the incompetent, and they're doing anything that they want. But now you can go back and correct all this mess. And we've talked about down in the past shows, you know, we've created the mess. Now we're the only ones who can go back in and correct it. So I don't know if I answered your question there or not, but.
Okay. I see what you mean, but
trust.
Actually it's that trustee from the beneficiary bank that's actually making the general deposit, though, isn't it?
Okay, yeah. He's making the general deposit, yeah, for me.
You are unmuted.
So you don't see it prudent to treat the withdrawal of that general deposit separately so it doesn't have any burdening effect on clarification, making a special deposit to the bank?
Well, yeah, we've added that additional step of withdrawing the general deposit and redepositing a special, yeah.
You are unmuted.
But I guess my question is what would you think about doing a 1 and a 3 twice? One for the one trust and one for the trust that was created that wasn't declared. Maybe we need to declare the other trust as well with that trustee so we can withdraw what he did. And maybe even at the same time we can even work on the so-called deed that he gave to the county that they're foreclosing on. with the lot block and the address description on it, which is their only interest in the property to begin with.
Treat them as two separate trusts.
Right.
Yes, that's what we talked about. Yeah.
You are unmuted.
Okay, thank you, Kristen. I follow your lead there. Thank you kindly.
Okay.
Sorry about the feedback.
Yeah.
Anybody else have a question? Probably have time for one more here. And we'll be wrapping it up for the night. It's all right on your phone if you got a question. Well, Kristen, I like what you said about, one of the callers had a question regarding, do we have any testimonies? Do we have any percentages of success? And you said, well, we're still in the infancy stages as far as getting a firm foundation on this. And I think there's a lot of wisdom in that.
Yeah, we have had some successes. We had a few people come on and give testimonies that they've had successes, cases closed down, a couple extinguishments of debts, and there's probably more. But, I'm not really pushing that. I'm pushing the foundation first.
Absolutely. Yeah, I think that's key because you have to be able to back up. You have to be able to support. You have to be able to defend whatever it is that you put your signature to.
Right. And that was one of the main reasons why I kind of sidetracked the workshop coming out with them, because I could see that I thought we were 3 steps ahead, but when I did some checking around, we lack a lot of foundational knowledge first, and we need that in order to move forward.
Agreed.
So we'll just take a little more time, and we'll let the kettle build up steam first, and then we'll get this locomotive running, when we get a full head of steam.
Absolutely. Well, why don't we go ahead and wrap it up for the night? Doesn't look like anybody else has a question. Folks,
all right.
Thanks so much for participating. Christian, thank you for coming on and sharing with us tonight. It's always a pleasure. And have a great weekend and great Memorial weekend. Safe. Everyone stay safe, and then we'll reconvene next Wednesday night.
Okay, thanks, Matt. Appreciate what you do.
Absolutely. Thanks, guys. Have a great weekend, and we'll see you next week. Night.